All right, I'm going to try and get through this quickly because I'm standing between us and lunch. So apologies for that. I'm here to give, I'm a legal advocate and from IAVGO, which is a legal clinic. We have been working with migrant workers in Ontario for about 15 years now. And so I'm going to give some legal context about how migrant workers are affected in return to work, and particularly around WSIB. My thesis, so I'm going to go through some of the main issues that are facing migrant workers, but my thesis in all of this is that there's two factors that are most critical that we see as advocates for change to policymakers, to tribunals and boards. And those factors, as we see them, are mobilization and advocacy by migrant workers themselves and the grassroots organizations that support them, and two, the research that has been done and is continuing to be done into the experience of migrant workers and the policy barriers and legal barriers that they face. So I'm going to start with mobilization because I think that's an incredibly critical part of the picture of how migrant worker policy and law is developing and hopefully will develop in the future. So these are some of the actions that migrant workers have taken alongside advocates and supporters, including participation in research and other advocacy and pressure tactics regarding against governments and regarding policies. Here are some legal challenges. There are a number of others. These are just a few that have happened in Ontario, where migrant workers are speaking out and demanding better conditions in terms of access to healthcare, to health and safety measures. This is one of our clients, Robert Solf, who himself filed a human rights complaint against the Workplace Safety and Insurance Board in Ontario based on their unfair practices in regards to his ability to recover after he suffered a devastating workplace injury. These are two of our clients, Denville and Kenroy, who again spoke out against the Ontario government when their OHIP was unfairly ended, when they had to stay in Ontario for treatment after a workplace injury. And this is our client, Kavan. Kavan also fought a battle successfully against the Ontario government when his OHIP was unfairly ended. And as a result of his advocacy and his bravery, the Ontario government actually changed their policy with respect to OHIP access for migrant workers. So these barriers have been covered by and are interesting, but I won't belabor them. In terms of the legal framing for migrant workers in Ontario with workers' compensation, you've heard a little bit about how the policy disadvantages them, but I think it's worth repeating just to give it a little bit of a framework. So loss of earnings, you've heard, payments are based on what workers could earn as if they were in Ontario. The result of that finding, so that deeming or whatever we're talking about, is that migrant workers almost only ever get 12 weeks of benefits. That compares to non-migrant workers who can get benefits to age 65. So 12 weeks, 3 months, and that includes workers, in our experience, who have to stay in Ontario for extended healthcare treatment. The WSIB, before they're at maximum medical recovery, before any of that, will say as soon as they think there's any practical chance that if there were work, they could be doing it as a cashier or whatever, will say now you are deemed, now you are able to work. So that results in most workers only ever getting 12 weeks. The second they repatriate, they get 12 weeks from that date. If they stay in Ontario because they have to for medical care, it's 12 weeks from whenever the board thinks they could have been a cashier again. So that is usually very soon after injury. And that is a radically different result than applies to other injured workers in Ontario. The WSIB also takes the firm position that migrant workers are unable to participate in retraining, again, even if they are here for medical care that they need to be here for, and even if they could participate in retraining, the board will say, we can't even retrain you because you don't have status to work here, except as a farm worker. So we will not retrain you, we cannot retrain you, instead you're deemed as a cashier. And the WSIB has refused at a policy level to offer any retraining in workers' home countries at all. The reemployment obligation, as you heard, does not apply. So the result of the approach in Ontario is an entire undermining of the legislative obligation on the Workplace Safety Insurance Board in Ontario to assist workers to return to work. Because in essence, migrant workers have no meaningful access to return to work. So we have a little bit of information from a Freedom of Information request. Hopefully there'll be more research arising from this request and further research. But just to give you a sense of the impact of these barriers, so looking at all agricultural workers in the years 2004, 2009, there were 314 workers on long-term loss of earnings benefits in that time period. There was one worker in the seasonal agricultural worker program on long-term benefits in that time period. So I'm going to talk a little bit about Michael Campbell in my remaining few minutes. Catherine mentioned this case earlier. Michael is a long-term client of the clinic. He suffered a back injury in 2008, his 9th year working in Ontario for the same employer. He was repatriated early because of his injury. He was unable to ever return to work because of the heavy labor that was required of his job here. And he was also unable to work his own farm in Jamaica. But he received, in his case, the policy was even worse back when he was injured. So he got 4 weeks of benefits from being completely disenfranchised, cut out of the labor market, 4 weeks. So Michael thought that wasn't fair, as you can imagine. So he decided to challenge the WSIB policy and practice on 2 grounds. He said it was wrong in the law. The law doesn't say that they should do this, and it was discriminatory to him under the Charter of Rights and Freedoms and the Human Rights Code. Michael actually tried to come to Ontario to his hearing at the WSIAT to testify, but he was denied a visa by the Canadian government on the grounds that they thought he wouldn't go back home. So because he couldn't attend, he ended up testifying on the phone, but we had a party planned for him, so we still had the party in his honor the night before the hearing. And I will say that Michael was actually quoted in the New York Times saying, "I want justice." So Michael was able to convince the tribunal that the board's practice was contrary to workers' compensation law, and that his benefit should be based on his ability to earn in suitable and available employment in his local labor market in Jamaica. This decision ran contrary to 3 previous tribunal decisions that had sanctioned the WSIB's practice. The tribunal had previously said that the act was only intended to provide compensation based on employment conditions in Ontario. And in fact, the tribunal had previously dealt with migrant workers from other provinces differently than migrant workers from the global south. So in some other cases, they had said workers from other provinces should get benefits based on their home province, but they treated workers from outside of Canada differently. Significant limits of Michael's case, alas. There is no precedential value. Essentially, it's not binding on future cases. And most importantly, the tribunal cannot order the WSIB to change its practice or policy. And in fact, the WSIB is actively seeking reconsideration of Michael's case, and that's currently under adjudication. And also, there was no adjudication because we won on the argument that it was inconsistent with the law of the challenge to the practice as discriminatory. Very briefly, also worthy of note that in 2018, the WSIB announced widespread changes to how they will treat migrant worker claims, including advanced travel for medical care and supporting workers to stay in Ontario where necessary for health care. These were very, very hard-fought victories. Years of advocacy, so here's some of the advocates, many, many advocates, some here, many others who fought for that. Significant ongoing barriers to access for migrant workers to WSIB, quite poor implementation of the new changes, now quite harsh imposition of the kind of better at work ideas of early return to work are starting to affect workers as they are staying longer in Ontario, so they're starting to see being forced back into unsafe, sometimes unsuitable job, and the ongoing presence of deeming as a barrier. Key elements of Michael Campbell's win, limits it has, but it's important. It's the first one that we know of, certainly in Ontario. And I think there's probably 2 key parts to it. One, the increasing public conversation. So there's no question that a few years ago, I'm not sure it would have been possible to win Michael's case. But as people become more aware of these systemic barriers to justice, I think that does make a significant change. And the evidence of researchers and academics, I mean, I argued the case, so I know what was important to the case. And the evidence about the fact that migrant workers who are injured in Ontario, that they cannot return on the migrant worker programs was the most critical piece of evidence. And that evidence was only possible because of researchers who had generated it on the ground. So, but for that, we would not have won. So I think that is evidence of the importance of the work that this project is doing. That's it.